In 1988, an electronics company built a robot. A blonde wig. Long evening gown. Big flashy jewelry. It stood next to a giant letterboard, turning tiles one by one, exactly the way you'd expect if you watched a certain game show every single night. There was just one problem. The company never asked permission. And the woman that robot was built to resemble was very much alive, very famous, and very willing to sue. This is the story of the ad that accidentally invented an entirely new area of celebrity law, all because a robot looked a little too familiar. By the late 1980s, Samsung wanted to make a splash in the American electronics market. So their ad agency came up with a campaign built around a single joke, predicting the wildly futuristic world of the year 2012. Robots doing everyday human jobs, decades ahead of schedule. Most of the ads in the series were harmless and silly: a robot news anchor, a robot boxer. But one ad, created to promote Samsung's VCRs, went in a very specific direction. The robot in this particular ad wasn't just any robot. It wore a wig styled exactly like a certain blonde television personality. It wore a long gown and large jewelry, just like she famously did. It stood beside a game board unmistakably designed to look like the Wheel of Fortune set. And it was posed in the exact stance she used every night on television, turning a letter tile with one hand. The caption above the whole scene read, "Longest-running game show. 2012 AD. Internally, Samsung's own team had a name for this ad. They didn't call it the robot ad or the VCR ad. They called it, in their own internal paperwork, the Vanna White ad. Here's the detail that turned this from a silly gag into a genuine legal crisis: Vanna White never agreed to any of it. She wasn't asked. She wasn't paid. And crucially, Samsung had paid several other real celebrities to appear in different ads within the same campaign. They understood exactly how this normally worked. They simply decided that, for this one, a robot built to evoke her would be cheaper and easier than asking. When White found out, she sued. Her case rested on a fairly bold claim, that a company doesn't need to use your actual name or an actual photograph of you to violate your rights. If they build something specifically designed to bring you to mind, your hairstyle, your clothing, your signature pose, the exact set you're famous for, that's still your identity being used to sell a product, whether or not your literal face appears anywhere in the ad. Samsung's defense was straightforward: it's just a robot. No name. No face. No actual photograph. How could this possibly violate anyone's rights? A lower court actually agreed with Samsung at first, and threw the case out. White appealed, and the case landed in front of the Ninth Circuit Court of Appeals, where everything changed. The court's reasoning became genuinely famous in legal circles. The judges pointed out that if you looked at any single element of that robot in isolation, sure, it meant almost nothing. Plenty of women wear blonde wigs. Plenty of people wear gowns and jewelry. Plenty of people turn letter tiles on a game show. But you don't look at a single element in isolation. You look at the whole picture. And when you put the wig, the gown, the jewelry, the game board, and the exact pose together in one image, there was, in the court's words, essentially no doubt who this was supposed to represent. The evidence that made this undeniable was almost embarrassingly simple. Samsung's own staff had already given the game away by naming their file the Vanna White ad internally, before any lawsuit ever existed. The court ultimately sided with White, ruling that a person's identity can be violated even without using their actual name or literal image. If the overall impression is unmistakable, that's enough. Samsung tried to take the case all the way to the U.S. Supreme Court. The Supreme Court declined to hear it, letting the ruling stand. White was ultimately awarded more than $400,000 in damages. This case didn't just end one robot's advertising career, it fundamentally expanded what using someone's likeness even means under the law. Before this ruling, companies generally assumed they were safe as long as they avoided using a person's actual name or an actual photograph. After this ruling, that assumption collapsed. Courts had now formally recognized that your identity can be evoked and legally protected through indirect signals alone: your signature pose, your styling, the setting you're known for, even a robot standing in for you. It wasn't universally celebrated, either. One dissenting judge on a later related ruling argued the decision swung too far, warning that if simply reminding audiences of a celebrity counts as a violation, virtually every impressionist, tribute act, and parody in American entertainment could theoretically be at legal risk. That tension, between protecting someone's identity and leaving room for satire, parody, and creative reference, is still argued over in courtrooms today. For advertisers and mascot designers specifically, the lesson landed hard and fast: get explicit permission, or build something distant enough from any real person that no reasonable audience could mistake who it's supposed to be. A costume, a character, or yes, even a robot, can still get you sued if it looks close enough to someone real that everyone in the room immediately knows exactly who you meant. So the next time a brand mascot looks strangely, suspiciously familiar, there's a good chance somewhere in that company's legal department, someone is being very, very careful about exactly how many of that person's signature details made it into the design. What do you think? Was the court right that identity can be violated without ever using someone's actual name or face? Let me know in the comments.